Good evening, everyone. I welcome each one of you to our AOR Aspirants Academy. This is our 64th lecture series. So, before dealing with this topic, it is our regular practice that we recite the preamble of the Constitution of India as our prayer. There is a reason for reciting preamble on every session, dear friends. One is firstly paying tribute to our founding fathers and mothers, that what was their vision about our nation. But those founding fathers, they are not living as of now physically, but spiritually their vision is still to be carried out by all of us. It is reminding oneself that you have a duty towards this nation. Being a citizen of this country, in addition to that, you are the lawyer practicing the apex court of India. So therefore, more responsibilities comes to you. So therefore, dear friends, it is our duty to remember the vision of our founding fathers and how to carry their vision in our daily life. So we have to imbibe those qualities, the key features of the Constitution of India that is enshrined in the preamble. That is why we say preamble our unity, preamble our dignity, preamble our sentiment, preamble our commitment, preamble our health, preamble our breath, preamble our soul, preamble our goal. With this thought, with this note, let us recite the preamble together, dear friends. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you so much, dear friends. In this 64th lecture, we are going to see the minority view of this judgment, 9 judges bench judgment, Mineral Area Development Authority versus Steel Authority of India Limited. You can ask me a very pertinent question. Sir, 9 judges bench, 8 judges on majority, sole dissenting judgment given by ladyship, and majority is always the law binding on the land. But what is the need to discuss a dissenting opinion? Dissenting opinion is equally important as that of the majority view. Why? The reason is Constitutional provision says so. Let me read Article 145, Clause 5. Because everything flows from the Constitution, dear friends. You must always remember this, because we are all practicing in the Constitutional Court, and Supreme Court is the custodian of the Constitution. If Honorable Supreme Court is the custodian of the Constitution, our Chief Justice of India, Honorable Chief Justice, my Lord B.R. Gave, Justice has always said that bar and bench are the stakeholders Equal stakeholders. Bench will respect the bar will respect the bench. So therefore, if you say that custodian of the constitution or custodian of the justice, we are part of the justice delivery system. We are equally responsible. So let us understand our responsibility, dear friends. So what is the dissenting view? Where does it flow from is Article 145 of the Constitution of India, which deals with rules of court. A, which says, which empowers the Supreme Court to regulate to the persons practicing before the court. So Supreme Court is empowered to frame rules. So which rule is now enacted or passed or regulated by the Honorable Supreme Court is Supreme Court Rules 2013, which prescribes the format of SLP, form number 28, deals with format of special leave petition. If you want to file a writ petition, then you need to comply with the rules mentioned under Supreme Court rules. If you want to file PIL, you have to disclose your identity. Who are you? What is your Aadhaar number? Everything has to be disclosed. Whether are you interested? Is there any vested interest? So where do you get all this? In the Supreme Court rules. Which power, which article empowered the Honorable Supreme Court? Yes, this is Article 145. And AOR, advocate on record, they say the rules as to the persons practicing before the court. So AOR system is an innovative system that is introduced by the Supreme Court with reference to this, that they can introduce a new system called AOR system, that they are empowered under the Constitution. Now coming to the dissenting opinion, Article 145 Clause 5. Article 145 Clause 5, no judgment and no such opinion. See how it is being started in a negative note. No judgment and no such opinion shall be delivered by the Supreme Court save with the concurrence of a majority of the judges present at the hearing of the case. So you should not pass any judgment or any opinion against the majority view. That is what so far we have read. But means you have to stop there. Yes, but means what do you say? We have to talk to our Constitution of India. Please teach me what is there. But nothing in this clause, that is clause 5, shall be deemed to prevent a judge who does not concur from delivering a dissenting judgment or opinion. So generally you sail with the majority, but doesn't mean that you don't give a dissenting opinion. You have freedom of speech and expression. You have your own voice to express your views. So for what purpose? Democratic functioning of the judiciary. How beautifully it is said. For democratic functioning of the judiciary, a dissenting voice may be today, tomorrow it may be a majority voice also. We have seen in many judgments, minority view has become a law of the land also. And secondly, that is first purpose of reading the dissenting judgment. The second purpose is being an advocate. You should be a good researcher, good interpreter of those key terms. So how the Honorable Supreme Court judges, majority has interpreted in a particular way the sole dissenting judgment by relying upon the same provisions, taking a different view, completely a contradictory view, that royalty is a tax. India Cement Limited is correctly said. Kesoram is incorrect. Kesoram is a serious departure from the India Cements. Why? 5 judges have clarified the 7 judges bench. It's a serious departure. And no necessity arises for interpreting India Cements Limited. This is what the dissenting opinion says so. So as far as lawyers are concerned, we must be curious to understand how a particular provision is viewed in 2 different angles and reach at 2 different conclusions. Let us see, dear friends. That is the value of the dissenting opinion. Due to paucity of time, I'll be reading only the few important points, dear friends. The following conclusions are arrived at by me, Honorable Justice B.V. Nagaratna, Her Ladyship. Number one, I hold that royalty is in the nature of a tax or an exaction. It is not merely a contractual payment. Majority they have said royalty arises out of the contract. It is a mere contractual consideration. But ladyship is viewing in such a way, it is not merely a contractual payment, but a statutory levy under section 9 of the Mines and Minerals Development and Regulation Act. Section 9A, capital A, relating to debt rent. The liability to pay royalty does not arise purely out of the contractual conditions of a binding lease. The payment of royalty to the government is a tax in view of list 2 entry 50 being subject to any limitations imposed by Parliament by law in the context of list 1 entry 54 read with section 2 of MMDR Act 1957. So her ladyship, see, now let us understand as an advocate. Now let us see the majority 8 judges has viewed from the contractual angle. Royalty arises out of the lease agreement, therefore royalty is not a tax. But ladyship is viewing from the statutory angle. What is that statutory angle? State government has power to levy tax, fine. But that is not an absolute power, that is subject to restrictions imposed by Parliament by law. So ladyship is coming to the Parliament by law. What is that law? MMDR Act, Mines and Minerals Development and Regulation Act. From that angle, ladyship is viewing. Therefore, it is not only the contractual, it is from the MMDR, section 2, section 9, section 9A. Therefore, it is not royalty, is a tax. Viewing from the statutory angle. Being subject to any limitations imposed by Parliament by law in the context of, what is the context? List 1 entry 54 read with section 2 of the MMDR Act 1957. Thereafter, Parliament is not using its residuary power with respect to imposing any limitation on the taxing power of the state under list 2 entry 50. Parliament is not using its residuary power. In majority they have said Parliament is using its residuary power. Under general entry they cannot impose tax. But here Parliament is not using its residuary power with respect to imposing any limitation on the taxing power of the state under list 2 entry 50. In fact, even the Validation Act 1992 enacted by Parliament was upheld having regard to list 1 entry 54 read with section 2 of the MMDR Act 1957 and not list 1 entry 97. There is yet another point, dear friends. List 2 entry 50 is an exception to the position of law laid down in M.P.V.SARAVANARAJA-LAW versus State of AP. Moreover, in the said case, the scope and ambit as well as the implication of list 1 entry 54 on list 2 entry 50 was not considered at all. Therefore, the principle stated in M.P.V.SARAVANARAJA is foreign to the instant case and the ratio of the said decision does not apply to the present case. No doubt, the legislative power to tax mineral rights vests with the state legislature. Ladyship is agreeing that no doubt the legislative power to tax mineral rights vests with the state legislature, but Parliament, though may not have expressed power to tax mineral rights under list 1 entry 54, it being a general entry, Parliament can nevertheless, on the strength of list 1 entry 54 read with section 2 of the MMDR Act. Now ladyship is viewing from list 1 entry 54, though it is a general entry, but still it being a general entry, Parliament can nevertheless on the strength of list 1 entry 54 read with section 2 of the MMDR Act 1957 impose any limitation on the power of the state to tax mineral rights under list 2 entry 50. So they have the power to levy, impose limitations on state's power. We have understood. Section 9 and section 9 capital A of the MMDR Act 1957 are two such instances of limitations imposed by Parliament on the taxing power of the state under list 2 entry 50. But majority view has held, we have read the entire provisions, there is no such limitations. But by reading the same provisions, ladyship is viewing that there are limitations. This is a unique entry and must be given its true and complete meaning, and while interpreting the same, one cannot be swayed by the principles laid down in M.P.V. Sundararamayya, as the same do not apply in this instant case. At the cost of repetition, it is stated that list 2, this is important, list 2 entry 50 never came for consideration in the aforesaid Sundararamayya case. Fourth point, list 2 entry 50 envisages that Parliament can impose any limitations on the legislative field created by that entry under a law relating to mineral development. So MMDR Act 1957 has imposed the limitations as envisaged in list 2 entry 50 in sections 9, 9 capital A and 25 etc. on the strength of list 1 entry 54. So ladyship is saying that by virtue of power provided to the Parliament under list 1 entry 54, they have imposed limitations by enacting a law, that is MMDR Act. Section 9 capital A, section 25 imposes limitation on the state's power. This is her ladyship's finding. I, however, concur. So even in the dissenting judgment, ladyship is concurring with the majority. In what way? I, however, concur with the learned Chief Justice with the scope of expression any limitations, because majority has viewed what is the meaning of any limitation. Limitations includes restrictions, conditions, principles, prohibitions. Therefore, ladyship is also concurring with the majority. I, however, concur with the learned Chief Justice that the scope of the expression any limitation under list 2 entry 50 is wide enough to include imposition of restrictions, imposition of conditions, imposition of principles as well as the prohibitions by Parliament by law. Sixth point, the state legislatures have legislative competence under Article 246 read with list 2 entry 49 to tax lands and buildings. Just now we have read to tax lands and buildings, but not lands which comprise of mines and quarries, to have mineral deposit as mineral bearing land do not fall within the description of lands list 2 entry 49. Just now the majority has held land means includes mineral lands also, but minority has held it is not so. Mineral land is different, but that will not fall within the list 2 entry 49. So mineral land will not fall within the meaning of land provided under list 2 entry 49. Similarly, states can tax such mineral bearing land which are not covered with the MMDR Act. So what is not covered under MMDR Act? State can levy tax. So what are those minerals? That is minor minerals under list 2 entry 50 and not list 2 entry 49 is as tax on exercise of mineral rights. Thus, mineral bearing lands cannot be taxed under list 2 entry 49. Majority has held what is the royalty, what is the yielding of mineral land which falls within the meaning of land under list 2 entry 49, but ladyship has viewed mineral land will not fall within list 2 entry 49. Further, the yield of mineral bearing lands in terms of quantity of mineral produced or royalty paid cannot also be used as a measure. You cannot treat the royalty or the what is the yield of mineral bearing land, that cannot be used as a measure of tax to levy tax under list 2 entry 50. Also cannot be used as a measure to tax such lands under list 2 entry 49. In my view, the decision in Goodrich does not apply to the present case and does not require any clarification. Next, list 2 entry 49 and 50 no doubt operate in different fields. List 2 entry 49 deals with taxes on lands and buildings, but list 2 entry 50 deals with taxes on minerals subject to any limitations imposed by Parliament by law relating to mineral development. There is no constitutional limitation on the competence of the state legislature to tax lands and buildings. However, states' competence to tax mineral rights is subject to any limitations imposed by Parliament by law relating to mineral development. List 2 entry 49, list 2 entry 50 are distinct and operate in distinct ways. List 2 entry 49 does not apply to mineral bearing lands. As such, lands are taxed in the form of royalty or dead rent in the context of exercise of mineral rights. The exercise of mineral rights is the basis for payment of royalty or dead rent. Consequently, value of mineral produced cannot be used as a measure to once again impose a tax on mineral bearing land under list 2 entry 49. If so, list 2 entry 50 would be rendered redundant. When you are going to levy tax even under list 2 entry 49, that means you are rendering meaningless. That is, list 2 entry 50 becomes meaningless. Next, 9 point. As list 2 entry 49 does not apply to mineral bearing land, the limitations imposed by Parliament by law relating to mineral development with respect to list 2 entry 50 would restrict the power of the state legislature to impose tax on mineral rights under the later entry. Thus, the power of the state legislature to impose tax under list 2 entry 50 is subject to Parliament imposing any limitations by law relating to mineral development. So, in view of the above discussion, the 11 questions referred to this bench are accordingly answered. In particular, I hold that is section 9, section 9A and 25 of the MMDR Act 1957 denude or limit the scope of list 2 entry 50. In majority, they have said MMDR Act did not impose any limitations on the state's power, but here ladyship has taken a view. Sections 9 capital A and section 25 of the MMDR Act denude or limit the scope of list 2 entry 50. That is number 1. Number 2, the majority decision in Kesoram is a serious departure. It's a note of caution, dear friends. The majority decision in Kesoram is a serious departure from the law laid down by the 7-judge bench in India Cement, which was wholly unwarranted, and therefore, in my view, the said majority judgment is liable to be overruled. Kesoram is overruled, and is overruled to the extent of holding that royalty is not a tax. Then third point, taxes on lands and buildings under list 2 entry 49 contemplates a tax levied directly on the land as a unit having a defined relationship with the land, and that land does not include mineral bearing land within its scope. In view of the declaration under section 2 of the MMDR Act 1957 made in terms of list 1 entry 54, and to the extent of the provisions of the said act, the state legislature is denuded of its power under list 2 entry 50, and list 2 entry 50 is a unique entry because it is the only taxation entry in list 1 and list 2 where the taxing power of the state legislature has been subjected to any limitations imposed by Parliament by law relating to mineral development. The dictum in M.P.V. Sundararamayya has not discussed on list 2 entry 50. Hence, the said decision has no bearing as such on the present controversy. The conclusion that royalty is a tax. The conclusion that royalty is a tax is the only exception to the position of law laid down in M.P.V. Sundararamayya. Of course, the scope of expression, any limitations in list 2 entry 50 is wide enough to include the imposition of restrictions, conditions, principles as well as prohibitions. In the result, in my view, the judgments in India Cement, Orissa Cement, Mahalakshmi Fabric Mills, Saurashtra Cements, Mahanadi Coalfields, Kannadasan, excluding to the extent overruled in Tata Iron and Steel and Tata Iron and Steel are correct, and therefore India Cements are correct. That is what ladyship has held. Therefore has got a binding precedent and cannot be overruled. India Cement cannot be overruled. On the other hand, the majority judgment in Kesoram is overruled to the extent that it holds that royalty is not a tax. Thereafter, the registry is directed to place these matters before the Honorable the Chief Justice of India for directions on listing the matters before the appropriate bench. Last but not the least, dear friends, I must place on record my sincere appreciation. This is where the role of bar comes in. I must place on record my sincere appreciation to the learned Attorney General, learned Solicitor General and their teams, learned Senior Counsel appearing for the respective parties, learned Instructing Counsel and learned Counsel for the respective parties for their valuable assistance to this bench. What is the meaning? A good judgment comes from good assistance from the bar. And they say bar is the mother of bench. Why? Judges are selected from the bar only. So bar must be very effective, very strong. Strong in the sense we should get updated with the latest developments. Strength means you should know what is the leading cases. You should know what is the importance of the preamble, and you should know that you should realize your own strength, that you are the custodian of the constitution, custodian of the justice. Your justice is embedded in the preamble. Social justice, political justice and economic justice. Ultimately, we are practicing in the Honorable Supreme Court, where the Honorable Supreme Court provides complete justice under Article 142. To do complete justice, we should do our complete homework. Thank you so much, dear friends, for your patience hearing. Please join us for group photo.